Hi, I'm Claire Edwards, and I'm here at the Claire Edwards Law Firm in Lafayette, Louisiana. I primarily practice family law, and that's what I want to take some time to talk about today. I want to talk about how you can use the procedures that are already built into Louisiana family law to make your divorce more amicable. So, one way that divorce goes down is you file your motion to get a divorce. So, first things first, is you're either filing a 102 or a 103 if it's a no fault divorce. So that 102 just says, hey, I'm ready to get divorced. We're going to wait some time and then we're going to finalize our divorce. And that 103 says, we've already been living apart. So now we're going to go ahead and file for divorce and then just do whatever paperwork it takes to confirm the divorce. And then we go on to community property. I want to talk about a different way of doing things. And then we go on to community property causes some concerns because during that waiting period between the 102 and when you can actually do your community property, you really do need to wait for that divorce judgment to be signed before you can then enter your community property judgment. Can you start negotiating things and then kind of file them at or around the same time? Yes, absolutely. That's a great way to do it. The problem is a lot of people get really overwhelmed with doing things like that because a lot of times there's other stuff going on. There's the child custody and the child support that's also going on. And while I'm very clear about the distinction between spousal support, child support, and community property, which is namely spousal support, child support is going to be your income and your expenses, and community property is going to be your assets and your debts. A lot of those can get really mingled just in people's minds and in people's emotionality, including lawyers' minds and lawyers' emotionality about what their client's dealing with. So, what I'd like to suggest is for those couples who really can handle things amicably and they really don't need one party suing the other party for divorce, why can't we handle our community property regime first and then file for divorce second? And I say it as a question. I actually do this with clients. And so what we do is we go through first our income and expenses because again, in a triage kind of way, we lawyers like to do the income and expenses first and the assets and debts second. So when we're going through our income and expenses, we're able to determine, is this a liquid asset? So if we have a house that needs to be sold, that is not a liquid asset. I don't care how expensive the house is. I don't care how much the house is worth. It's not liquid. You can't take money, pluck it off of the walls, and spend it. Are we dealing with savings accounts that are not term limited? For example, a short term CD or just a generalized savings account. Now, those are liquid. You can pluck money right out of those. And then do we have retirement accounts tied up? Again, not liquid. That's not going to be any kind of help in the short term in our triage. So there's a lot of people who will end up having a lot of assets that they can't use. So we have to figure out, how do we handle our income and expenses that are going to keep happening every single month, month after month. And when we move into two different households, we're going to have more expenses because we have more homes to manage. We have two instead of one. If a couple does this while they're married, they are able to get used to the new normal while they're married, and they can even set up child support, child custody if they want to. Um, I don't love to file child custody documents until I file the divorce. So I do recognize that that's a sticking point for some people. Um, and if that's the case, like you really don't trust your ex with your kids, then how could you possibly trust them with your money? So we do need to put you in that 102 category where we do your divorce first and then do your custody, spousal support, child support, and then do community last. That's fine, I get it. But for those of us who do trust our spouse enough during this divorcing process to maybe bird nest or even just move the children from place to place, awesome. That gives us time to adjust to this new living situation while we're still married before anyone's filed any paperwork. And why is it a big deal to file this paperwork? Because it messes up your ability to move those unliquid assets. A lot of lawyers, of course, myself included, like to file what's called a restraining order against property or an injunction against property. And there's two different kinds. There's one that's in the Louisiana Ancillary Codes, Title 9, and that happens after the divorce is filed or when the divorce is filed. And we say you may not alienate or encumber or do anything. You cannot take out loans. You cannot uh, pull money out, sell houses. Can't do it. Don't do it. We got a judge to sign it saying you can. The second kind of injunction is found in the Code of Civil Procedure. I believe it's 3601. Might be wrong on the number, but that one's allowed outside of divorces. That one's not exclusive to family law. So that's a good one to file while you're waiting for your community property to be handled. But after your divorce has been granted and after that first restraining order has expired, whether the judge put a date on its expiration or not, it's a smart move to file the Code of Civil Procedure one if you're still waiting. But again, look, my whole argument right now is let's handle all of this before anybody files divorce. Because we're in this world where both parties are still controlling the property 100% because they're still married, put your house for sale. See if you can get a buyer. Give yourselves a deadline. Okay, if we can't get a buyer in 3 months, then we'll file for divorce. If we can't get a buyer in 4 months, then we'll file for divorce. What about those retirement accounts? Can you move any assets while you're married? I'm pretty positive your IRA manager can bump stuff around while you're married. If they need it in a divorce document, cool. They'll put it in writing to you that they need you to put in writing to them how much needs to be moved when you get divorced. Now, here's the thing. If you start to do all of this unraveling while you're still living together under the same roof, you're only going to be allowed to file that 102 divorce when you're ready to file the 102 divorce because you haven't hit your no fault separate living arrangement yet. You haven't done 180 days if you don't have kids or 365 days if you do have kids. But if you've made it a whole year, your stuff is unraveling, your house is sold, your cars are in your own names, your debts are getting paid off because your house is sold. What the hell do you need to spend money on a community property lawyer for? You don't. So I'm advocating to use lawyers like me and other family law attorneys to guide you through your community property while you're married. We can save you tens of thousands of dollars if you work with us while you're married. I'm not saying you and your spouse need the same attorney. I'm saying work with an attorney while you're married to be sure you're reaching your community property goals, and then go to divorce if your spouse is not working with you to achieve what is best for both of you. Because again, in Louisiana, the way our divorce laws are written, we really shouldn't be filing that community property until after we've had that divorce. That stresses out a lot of people because a lot of items are in fact assets or debts and therefore fall into that community property category. And therefore, when those restraining orders start going out against property or those lawyers start giving you advice, don't sell, don't loan, don't encumber, my small business people are freaking out because can they continue doing business? Yes, you can, for sure, as long as it's the regular course and scope of business. But this is a great opportunity to expand. I'm missing my opportunity to expand because I'm going through a divorce. The lawyers, we don't want to see that for you. Maybe your ex is vindictive and wants to see that for you. That's between you and yourself of 10 years ago who got in a relationship with that person. But what I'm offering again is use us lawyers to your advantage. Use us before you've started your divorce so that we can do as much with your property as we can without having to file in court or fight in court. And again, I firmly believe this is something that will save tens of thousands of dollars, especially in the Louisiana legal market. So I'm Claire Edwards. I am a family law attorney in Lafayette, Louisiana, and I am so thankful that I got a second to talk with you about community property and the distinction between handling your community before you file for your divorce versus handling your community after your divorce is finalized. And I hope that that offers some additional opportunities.